Good afternoon. Attorney Sean Gellis here. I take complex legal concepts and break them down into easy to understand sound bites. I'm grinding on a Saturday, decided to come outside, take a couple minutes, get some fresh air. And while I'm out here, I'm going to attempt to explain a civil litigation case to you, a whole trial from start to finish in under 3 minutes. Wish me luck. All right. So it begins with a complaint. A complaint is a document whereby one party is alleging things against another party. Usually you have to put in who the parties are, the allegations, and what it's about. So if it's like a breach of contract case, it would be a complaint for a breach of contract. Let's say we'll go ahead and use that. You go ahead and file that. You then serve the other side. That is the person that you're suing. That person has the right to file a motion to dismiss. A motion to dismiss is a motion that tests the sufficiency of the pleading. It looks at the document and says, if everything was true, would this case move forward? Here's an example of one that wouldn't work. If someone filed a lawsuit saying you punched them so hard that they flew to the moon, landed on the surface of the moon, and then flew back to Earth, that would probably be dismissed. Why? Because it's impossible. So after that, the motion to dismiss stage is heard. Your case may or may not be dismissed, and the plaintiff can amend the allegations, and that means, rewrite them to make them sufficient. Once you get through that stage, the person who's being sued, the defendant, files an answer. The answer is where you admit or deny every single paragraph, and you have the opportunity to write affirmative defenses. Affirmative defenses are things like where you would say, essentially, confess and avoid. They're defenses that say, like, yeah, well, even if this is all true, I'm not liable for this reason. Once the answer is filed, you then have a complaint and an answer. So there's allegations and denials of the allegations. Discovery then begins. Discovery is the process where both parties exchange all their evidence between each other in an attempt to make sure we have open and fair, transparent litigation. There's 3 forms of discovery primarily, plus depositions. The 3 are interrogatories, which are written questions under oath. They write questions and they send them to you. You have to write down written, sworn answers under oath and respond. There's admissions. Admissions are where they request that you admit things, like admit your name is John, admit you live at this place, whatever. You admit them or deny them. Then you have requests for production. Production requests are where the party can say, hey, here's some evidence, or give me all the documents you have about this thing. I want all the evidence that you have or documents, and you have to produce those documents. Now, throughout this process, there may be some disputes, what's relevant, what's not. Those are discovery disputes. Assuming that all goes well, there's also depositions usually after the discovery and the documents have been exchanged. You sit down under oath and you have some depositions. At the end of the depositions, all the evidence is pretty much out. Everybody pretty much has a handle on what the other person has, right? Then they file this thing called summary judgment. It's kind of a complicated concept. The test is whether there are no disputed issues of material fact and the movement is entitled to judgment as a matter of law. Looks like I ran over the 3 minutes, but we're almost done.